My name is Jordi Vilanova, and I speak on behalf of the Catalan National Assembly, a grassroots organization defending the right to self-determination of the Catalan people. Today, we see how counter-terrorism laws are being tightened across the OSCE region with far-reaching human rights implications. This worrying dynamic is exacerbated by the labeling of civil society and dissenting voices as terrorists or extremists, curtailing their legitimate labor. In Spain, accusations and investigations for terrorism-related crimes against Catalan activists has become common practice by police units, prosecutors, and investigating judges. One of the most alarming cases is that the non-violent Catalan pro-independence committees for the defense of the Republic falsely accused and prosecuted for terrorism and of illicit manufacturing of explosives. On September 23, 2019, the Spanish paramilitary police detained 8 members of the committees in the so-called Operation Judas. The prosecution claimed that they belonged to a Catalan secessionist terrorist group, allegedly called the Tactical Response Team, preparing to commit terrorist attacks. In June 2020, 4 more people were included in the investigation, bringing the total up to 12. Some of them spent between 3 and 4 months in pre-trial detention until they were released by the criminal chamber of the Spanish National Court, since the Spanish paramilitary police were unable to prove the existence of explosives. Despite the clear lack of evidence, the activists will be judged in the coming months for the crimes of terrorism and of illicit manufacturing of explosives anyway. Their attorneys have not been duly provided with all the documentation, and on several occasions the lawyers have obtained information and news on the prosecution through irregular leaks to the Spanish press instead of by the formal established channels of discovery. Charges and prosecution for terrorism have been used in other cases against Catalan activists, such as in that of Tamara Carrasco and her brother Adrià Carrasco, in order to intimidate them. Tamara was confined for 411 days to her town of Viladecans until the charges of terrorism and rebellion were dismissed for lack of evidence. Adrià went into exile in Belgium in 2018 until the charges were dropped in 2021. Even though, on some occasions, the judicial processes result in acquittals, this repressive practice by Spanish authorities represents a violation of the right to the presumption of innocence, the right to defense, and the right to privacy and honor of activists and civil society. Furthermore, this practice of systematic criminalization, aggravated by the exceptional conditions allowed by the Spanish anti-terrorist legislative framework, has a general chilling effect on Catalan activists. I need not point out which of the authoritarian guidelines described by the introducer, Ms. Potacua, these cases follow. In any case, the Catalan National Assembly calls on Spain to comply with human rights obligations while countering terrorism and to put an end to this pattern of intimidation and reprisals against Catalan activists, and calls on the OSCE institutions to engage with Spanish authorities to make sure that the necessary measures are taken so the human rights of activists are respected. Thank you very much.